I guess it would help if I unmuted myself. Good afternoon. I hope you all are well this afternoon.
We are.
afternoon.
Thank you, Your Honor.
Ms. Bridgewater, good afternoon. When is the SAP reset date?
It's going to be July 6th because our next available falls on the 4th of July, and I don't think any of us want to be here that day.
Okay, very good. Thank you. Let's see, it's right. It's almost 2 o'clock. Where are we starting this afternoon?
Good afternoon, Your Honor. Not ACDC. Courtroom 3, position 1, Ms. Alquist.
Good afternoon.
Good
Ms.
afternoon, Judge.
Alquist.
Attorney Chad Trinacosta here, appearing for Ms. Alquist as well.
Yes, good afternoon. Let's see. Ms. Alquist, I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Alquist, you've been charged in case 23 CR 003870A with criminal trespass and disorderly conduct. Who do we have on from pre-trial this afternoon? Ms. Roberts, good afternoon.
Afternoon. She has 2 cycles, the last arrest being in 2011. That was a DUI conviction. She has a second DUI conviction also in 2011.
Okay. Good afternoon, Ms. Bickerstaff.
Good afternoon, Judge Morrow. Okay, so this incident occurred yesterday at 342 Pebble Trail in Alpharetta. And this is where officers arrived and they heard shouting coming from the backyard. And so officers then spoke with Mr. Andrew Alquist, who told them that his wife, the defendant, had been pounding on the back door and shouting. She eventually broke the door, and he told officers it'd be about $500 to fix. Officers did observe the defendant yelling profanity pretty loudly, and the defendant told officers that her and her husband were experiencing a rough moment in their marriage right now, and they're currently separated. The officer noticed the glass door was completely shattered from her banging on it. And the defendant told officers that she was trying to make contact with her husband, and she said that she knew that she had made a mistake. Our office was able to speak to Mr. Alquist today. He let us know that they're married but separated. And he also stated that this happened because he wouldn't allow the defendant near him because of the way that she was acting. He did confirm that the door was shattered. And he said the only reason he called the police was because he wanted her to leave and he did not know what else to do, Your Honor. He also let us know that he's not looking to press charges and he doesn't mind her coming to his residence. So the state's recommendation is a $2,000 surety bond, $1,000 for each of the charges, 1-day anger awareness course, no further violent contact with Mr. Andrew Alquist, and to stay away from the 342 Pebble Trail address, as well as no alcohol, drugs, or weapons while out on bond. And Mr. Alquist is on the Zoom call, so I'd like to sound for him.
Okay, I see him there. Let me go to Mr. Trinacosta
And yes,
first.
Judge, I believe the facts and circumstances surrounding are somewhat accurate. She didn't mean to break the door or the window. It just happened when she was knocking on the glass. She wasn't being destructive. She was just there trying to get in contact with him. And he would confirm that as well. I did speak with him in depth about this. He actually is okay with no violent contact. We're not asking for no contact. We're asking for no violent contact. And also, I mean, considering the lack of a criminal history, and she has been in jail for actually 2 days. It happened 2 days ago, or maybe like in the middle. She was arrested in Alpharetta, held in the Alpharetta jail, and then had to be transferred to Rice Street, waited overnight last night, and then through today. So it's been more than 2 days, essentially. By the time she books out, it'll be probably 3 at this point. And so we're asking for a signature bond, just considering her lack of history. And also, obviously, the quote unquote victim is on the line, and he supports everything that I'm saying as well.
Okay, thank you, Mr. Trinacosta. Mr. Alquist, if you would like to address the court, now is your opportunity to do so. You do not have to, but if you would like to address the court, I'll need for you, I'm not sure if you're driving or not, but if you are, I'll need for you to pull over and unmute yourself.
I'm not driving, I'm stationary.
Okay, very good.
Um,
Can you raise your right hand for me, Mr. Alquist? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Yes, sir. What would you like to tell the court?
I confirm everything that Attorney Chad Trinacosta just said, and I do agree with what he said, and he's speaking for me right now.
Okay, and you're not afraid of her?
Not at all. This has
Does
never
she-
happened before.
Okay, and does she, and I know that you all are going through some things. Does she need to be at the Pebble Trail course, the Pebble Trail residence?
I have no problem being in contact with her if she came there, with communication. I have no issues with this. We have been talking, we've been in counseling, and we are still close. It's just, it was an isolated incident, and we just like to get past it.
Okay, thank you, sir. If there's nothing further, it's going to be $1,000 signature bond on each charge, which makes it a total of a $2,000 signature bond through the jail. No further violent contact with Mr. Andrew Alquist. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Alquist. You also, Mr. Alquist.
Thank you very much, Judge. And may we be excused?
Yes, have a good
Have a good day.
afternoon.
We appreciate it. Good to see you. See you
You're
soon.
welcome. You also.
Thank you.
Who do we have next?
Good afternoon, Judge Morrow. This is going to be position number 4, Mr. Connor Clark.
Good afternoon. I hope you're well this afternoon.
Thank you.
Good afternoon, Mr. Clark. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah, that's fine.
Thank you. Mr. Clark, you've been charged in case 23 CR 003863H with battery family violence. Is there a history? Ms. Roberts?
Correct. First arrest.
Good afternoon, Mr. Walker.
Good afternoon, Your Honor. In this case, law enforcement was dispatched to 10180 Belladrum Drive in Johns Creek, Georgia. They spoke to the victim, who is the defendant's father, Mr. Kevin Clark. He advised that it was a verbal altercation turned physical when his son punched and kicked him. Officers did observe a visible injury, hence the battery family violence. The state is asking for a $3,000 surety bond, no further contact with the victim, and to stay away from the incident location. I believe Mr. Clark is on the line. I believe it says Kevin's iPhone 13i mini. So at the appropriate time, we would ask that you sign for the victim.
Okay. Good afternoon, Mr. Trejo. Good to see you.
Good to see you as well, Your Honor.
Would you like me to speak with the alleged victim first, or would you like to present first?
Please, Your Honor. I think we can hear from the other party.
Okay. Mr. Clark, if you are on the line and wish to address the court, now is your opportunity to do so. If you would like to address the court, I'll need for you to activate your camera, unmute yourself, and I'll have to swear you in.
Okay, Your Honor, hang on.
Okay. There you go. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. What would you like to tell the court?
I think the assessment of what was presented was accurate. I haven't heard from the other attorney yet, but yes, Connor did, verbally and physically, assault myself, and actually tried to hit his mother with stuff that he was carrying as well, which is what kind of preceded the event.
Okay. And the Belladrum Drive address, that's your address?
Correct. That's my home.
Okay, and you would like for Connor to stay away from both you and your home at the present time?
Correct. Yes.
Okay. Anything further that you'd like to tell the court?
Not at this moment.
Okay. Does he live at that Belladrum Drive address?
We had let him stay there as a guest with conditions that he had signed and notarized, and he's not followed them whatsoever.
Okay. Does he still have belongings there that he's not going to need to get?
He has some clothes that he can
Okay.
that he can get.
Okay, all right. Thank you, sir.
You're welcome.
Mr. Trejo?
Yes, Your Honor, we would ask for a signature bond, and the main reason why we would do so, Your Honor, is that in speaking with Mr. Clark, he indicated that he is not working at the moment. He also indicated that he does not have another place to go other than the location where the incident occurred, where he has been living for some time. Given the fact that this is his first arrest, Your Honor, given the fact that he has lived in Atlanta for his entire life, ties to the community, I don't believe that he would be a flight risk. But our main concern is a situation, Your Honor, where he would simply not be able to make bond. Furthermore, Your Honor, we would ask for no further violent contact, again, given that it is his first offense and given that he does have some items at the home that he would need to be retrieved. And because as it stands right now, based on my communications with Mr. Clark, it is unclear what his housing situation would be if he were to leave the current address.
Okay, well, given that his father is his residence, I'm not going to allow him to, and his father does not want him there, nor does his father want contact with him. I'm going to order that he can have no further contact and that he's going to have to stay away from that residence. But Mr. Trejo, I will give him a $3,000 signature bond through pre-trial per the judge, 1 day anger awareness, no further contact with Mr. Kevin Clark, and to stay away from the Belladrum Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. He's to have no drugs, alcohol, or weapons while out on bond. Okay. Good luck to you, Mr. Clark. Both of you, Mr. Clarks.
Thank you, Your Honor.
Thank you, Your Honor.
Position 13, Ms. Sherman.
Good afternoon, Ms. Sherman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Sherman, you've been charged in case 23 CR 003869J with criminal trespass, possession and use of drug-related objects, and a second count of criminal trespass and damage to property. Is there a history?
Yes, I'm showing 25 cycles, 11 out of Georgia, 1 out of Nevada, 1 out of Louisiana, 1 out of North Carolina, 10 out of Virginia, 1 out of Florida. Last arrest was February of this year out of Gwinnett County for theft by shoplifting. That is an open case. Appears to be on probation out of Gwinnett County for possession of cocaine and possession of a scheduled to control substance. From April of 2020, it was 5 years probation. 2014, possession of marijuana conviction out of Louisiana. 2011, shoplifting conviction out of Virginia. 2011, contempt of court conviction out of Virginia. 2012, possession of a controlled substance conviction out of Virginia. 2 FTAs, 2012, 2020, and 2 probation violations in 2022 and 2012. Nothing further.
Thank you. Ms. Bickerstaff?
Yes, Your Honor. So this defendant has a cross defendant, and which is position 8, where the facts are the same. So we can, if you want to take that one up as well.
Okay, and that's Mr. Harvey?
Yes, Mr. Harvey.
Okay, is this Mr. Harvey in courtroom 2?
No, Mr. Harvey's over here. He's coming up now.
And
Okay.
Your Honor, I do
Yes.
represent Mr. Harvey, and although the police reports are the same, it's vastly different. So if Your Honor wants to hear them together, I just want to give you a heads up that it's going to be completely different arguments.
Okay, very good. Thank you, Ms. Wright. So what I'm going to do is I'm going to continue to hear Ms. Sherman, and then I'll begin with Mr. Harvey when I'm done with Ms. Sherman, okay?
Thank you, Your Honor.
You're welcome. Let's see. Ms. Bickerstaff?
Yes, okay. So Your Honor, this incident occurred June 17th of this year at the Linridge Martin Manor located at 1075 Woodland Avenue Northeast. And this is where on June 11th, Miss Nakivia Myers called officers and she informed them that several people were inside an apartment at the complex. And so then on the 17th, she went into an apartment that she was making Airbnb arrangements for, and she noticed that the back window was slightly open and that window had minor damage to it. And so she called officers because she was afraid to go inside the apartment. So officers went inside the apartment and they found a male and a woman, the defendant here in position 8 in a bedroom sleeping. They both were nude, and beside the bed on the nightstand, there were crack pipes and syringes and clear baggies that appeared to have drug residue in them. And so officers tried to awake Mr. Harvey, position 8, by using pressure points, but he was unresponsive, but he just mumbled words. And so officers sent him to Grady for a possible drug overdose. However, Ms. Sherman, officers were able to wake her up, and they discovered that she had 2 active warrants, one in Gwinnett and one in Leoburn, for drug possession and shoplifting. And Ms. Myers told officers that she had made contact with Ms. Sherman a few days previously, and she gave her a trespass warning for entering the apartments there. And she stated that Ms. Sherman was bragging to Ms. Myers that her and her friends had trespassed that residence several times before, Your Honor. Ms. Myers told officers that the apartment was completely trashed and it had drug paraphernalia in the apartment. And so our office was able to speak to Ms. Myers, and she let us know that she is the apartment manager of the complex. And again, like a few weeks ago, she encountered the female, Miss Sherman, and she told her to stay away. And she told us that Miss Sherman was saying that there was a friend that said that they could stay in the residence, but she did say that Miss Sherman and her friends have been terrorizing people in the apartment complex, Your Honor. For these reasons, the state's recommendation is a $2,500 surety bond, $1,000 for the criminal trespass damage to property, another $1,000 for criminal trespass, and $500 for the possession of drug-related objects, and to stay away from 1075 Woodland Avenue, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Myers is on the Zoom call, I would like to sound for her.
If Ms. Nakivia Myers is on the call and wishes to address the court, now is your opportunity to do so. Does not appear so, Ms. Bickerstaff. Good afternoon, Ms. McLeod. Is this your case?
It is, Your Honor. Good afternoon.
Good afternoon.
My client is 32 years old, and we acknowledge that she does have some history, Your Honor, but she tells me that she's currently homeless and has been homeless for the past 6 months, as well as unemployed. She also tells me that she's pregnant, Your Honor. She's in no position to pay any kind of paid bond. It's just what it is. She has no money. She tells me that she actually was staying with who she thought was a friend at this location, which she thought that the friend was actually living there legitimately. She did not learn otherwise until she was awoken by the police, and they were saying that she had no business being there and she was taken to jail. So the narrative which was given by the prosecutor, based on what the client tells me, she did not do that because she said that was her first occasion being there. She'd just been invited over and she fell asleep. So I would ask the court to take her circumstances into consideration in setting her bond. She's pregnant, she's homeless, and she's unemployed. Nothing further, Your Honor.
Anything further, Ms. Bickerstaff?
Yes, just briefly, like Ms. Myers let our office know that the tenant that was occupying that apartment had moved out that morning, and the cleaning crew had just left it. So she believes that not Ms. Myers, but the defendant and her friends are like waiting for people to leave the apartments, and then they go inside and do what they do.
Okay. For the criminal trespass, it's going to be a $250 good bond. For the possession and use of drug-related objects, a $250 good bond. For the criminal trespass and damage to property, a $500 good bond. It makes for a total of $1,000 good bond. Stay away from the Woodland Avenue address and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Sherman.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, enjoy the rest of your day, Ms. McLeod.
Thank you, Your Honor. You too.
Thank you. So let's go on to Mr. Harvey, position number 8. Good afternoon, Mr. Harvey. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Okay, thank you, Mr. Harvey. You've been charged in case 23 CR 003868J with criminal trespass and damage to property, criminal trespass, and possession and use of drug-related objects. Is there a history, Ms. Roberts?
33 cycles. Last arrest was March of this year for FTA. Has 3 other FTAs, a total of 11 probation violations, 2 parole violations. Appears to be on probation for theft by shoplifting. That sentencing date was June 2nd of this year, 1 year probation. Also appears to be on probation out of Walton County for burglary. That is from 2008. It was 1 year confinement, 15 years probation. 2005 conviction for entering auto with theft by receiving stolen property. 2006 conviction for theft by receiving stolen property. 2007 and 2022 conviction for battery. And 2009 and 2020 conviction for disorderly conduct.
Thank you. Anything to add to the facts, Ms. Bickerstaff?
The only difference with this defendant is that Ms. Myers hadn't come in contact with him previously, like the previous defendant. So because of this, the facts are the same. The state's recommendation is a $2,500 surety bond, $1,000 for each of the criminal trespass charges, and then $500 for the possession of drug-related objects, and to stay away from 1075 Woodland Avenue, as well as no alcohol, drugs, or weapons.
Yes, Ms. Wright.
Yes, Your Honor. Mr. Harvey has been a lifelong Georgia resident. He's 36 years old. My understanding is with the failure to appear is that he resolved that case with us. He was put on probation earlier this month, but probation hasn't truly began yet. It takes a couple of weeks for it to kick in. As of this incident, he had no idea that this was an Airbnb. He was invited over to hang out. He was awoken. Actually, he woke, the next thing he remembered, he was at the hospital. I don't think that there is sufficient, there's no mens rea for a criminal trespass. He didn't know that that property wasn't his, or it wasn't, he wasn't allowed to be there, that it wasn't his friends. He told me that he walked through the front door and he was welcomed in as a guest. He did not enter through any side door or any back door. For that reason, I would ask that for at least the criminal trespass that Your Honor consider a signature bond on that. He has also requested that my office work with him to get him into some kind of sober living facility type of thing, because after waking up in the hospital, he recognizes that some things need to change.
Okay. Anything further, Speaker Staff?
Nothing further, Your Honor.
For the criminal trespass and damage to property, a $500 good bond. For the criminal trespass, a $250 good bond. Possession and use of drug-related objects, a $250 good bond. Makes for a total of $1,000 good bond. Stay away from the Woodland Avenue address. No drugs, alcohol, or weapons while out on bond. Ms. Wright, if you will have a social worker go by and assist him with housing. If he does not get out prior to the SAP calendar, if you will have that social worker report to me, and at that time, if there's a request for a modification of the bond, it'll be considered at that time. But I'd like to see if we can assist him with housing.
Yes, Your Honor. Thank you.
All right. Good luck to you, Mr. Harvey.
Thank you, sir.
Hey, excuse me, Miss Milton, if you don't mind, we have a visitor here for Mr. Gibbons, if we can do him next. And then go back to one-on-one, win and win. This is gonna be position 6, Mr. Gibbons, and he has a visitor in the gallery, Judge.
Okay, thank you. Good afternoon, Mr. Gibbons. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Gibbons, you've been charged in case 23 CR 003877C with willful obstruction of a law enforcement officer and possession of marijuana less than an ounce. Is there a history, Ms. Roberts?
Cycles. Last arrest was from October of 2020 for DUI and possession of marijuana less than an ounce. There's no disposition, so that case appears to be open. And then 2 convictions, both for driving while license suspended or revoked, 2015 and 2016. Nothing further.
Let's see, Mr. Eggers, is this your case?
Yes, it is, Your Honor.
Yes, good afternoon. You can proceed.
Yes, the state has brought 2 charges for obstruction of a law enforcement officer and possession of marijuana under 1 ounce. The event occurred yesterday, June 18th. The location was intersection of Auburn Avenue and Bell Street in Atlanta. Mr. Gibbons was a passenger in a vehicle that was observed by law enforcement doing a burnout. The vehicle was stopped. And during questioning, Mr. Gibbons rolled up his window on the officer. And that's the basis of the obstruction of law enforcement. The officer detected an odor of marijuana coming from the vehicle. The passengers in the vehicle were searched, and Mr. Gibbons was found to have 4 grams of marijuana in his pocket, which is the basis of the marijuana possession under 1 ounce. Mr. Gibbons has a history of not following driving laws. Alcohol and drugs were found in the vehicle, a bottle of cognac along with the marijuana, and also there was a firearm that was in the underneath his seat. So we're having concerns about that. We are asking for the state, for these reasons, are asking for a $1,000 surety bond on count 1 and a $500 signature through the jail on the 2nd count, and then no drugs, alcohol, or weapons while on bond.
I'm going to give him a signature bond based on his history. It's a $500 signature bond on each charge, which is a $1,000 signature bond through the jail, no drugs, alcohol, or weapons while out on bond. Does that suit you?
Sure does, Your Honor.
All right, good luck to you, Mr. Gibbons. And I don't know if the person needs to speak. I've given him a signature bond on this matter, so I'm happy to hear from whomever's there, but he has a signature bond.
Okay, thank you, Judge.
Okay.
Also for position 8, Mr. Harvey, the total bond, was it 5,000 or 1,000 good?
Mr. Harvey's total bond was 1,000 good.
1,000, thank you.
Yes.
Next, we have position number 15, Ms. Stone.
Good afternoon, Ms. Stone. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003871C with criminal trespass. Is there a history, Ms. Roberts?
2 cycles. Last arrest was December of 2018 for theft by taking a driving while license suspended or revoked. The driving while license suspended or revoked, the conviction in 2019. Nothing further.
Mr. Walker?
Yes, Your Honor. Law enforcement was dispatched at 4492 Muhammad Drive. Upon arrival, they spoke with the owner of that property, Mark Berzen, Berzen. He explained to law enforcement officers that The defendant in this case had previously been at his home 3 days prior. It's an unoccupied property that he owns. At that time, she was discovering his attic. He asked her to leave the property, just for her to return on 3 days later, which was 6:19 or early this morning. He did call 911. Law enforcement officers did come out to the property and they were able to arrest the defendant on site. She's been charged with 1 count of criminal trespass. We are asking for a $1,500 surety bond, no further contact with the owner, Mark Berzin, and a stay away from the incident location, 4492 Muhammad Drive.
Mr. Trejo?
Yes, Your Honor. We have no objection to a stay away order or to a no further contact with the complaining witness in this case, Your Honor. Ms. Stone indicated that this was a stranger. She also indicated to me that this was an isolated incident. She indicated to me that she has lived in Atlanta her entire life. Her family is here in Atlanta as well. She had previously been staying with her grandmother and indicated to me that she had some other family members living in the home at that time that that may have been involved in some situations that she herself did not want to be a part of. And so this was an unfortunate attempt to remove herself from that situation. She's indicated to me that, like I mentioned, Your Honor, this will be an isolated incident. She believes that she'll be able to move in with her mother, who she has had some contact with as well. She is gainfully employed. She works at Walmart. She's been working there for about 2 weeks, so she is coming up on her first pay period. We would ask for a signature bond or a bond that is limited to no more than $1,000, so that she can stay on her feet and continue working and deal with this case in due time.
Okay, it's going to be a $2,000 signature bond through the jail. Stay away from the Muhammad Drive address. No further contact with Mr. Berzin, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Stone.
Position 3, Kane.
Good afternoon, Mr. Kane. I am Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You agree to have your case heard by video?
Yes.
Thank you. Mr. Kane, you've been charged in case 23 CR 003875Y with simple battery against a police officer, police dog, corrections, or detention officer. Is there a history, Ms. Roberts?
First arrest.
Mr. Eggers?
Yes, Your Honor. Mr. Kane is fairly young, only 18. He was on January 30th, he was at Frederick Douglass High School at 225 Hamilton Holmes Drive. The officer, Atlantic Public Schools officer, Ebony Robinson, was called by an assistant principal. The defendant apparently did not understand that there was a process to re-enroll. He had been a previous student, but was no longer enrolled at the school, and was told that other things had to be done for that to happen. He was told to leave the premises. Officer Robinson was escorting Mr. Kane out of the school when he pushed her in the head area and would not proceed to the exit. It is the first arrest. The state is asking for a $2,500 surety bond on the charge, a stay away from Frederick Douglass High School unless he's re-enrolled, and a no drugs, alcohol, and weapons.
Ms. Wright?
Your Honor, Mr. Kane is 17 years old. He had been in alternative school and he was trying to get re-enrolled in good old-fashioned school. He thought that he could just go and re-enroll himself. It turns out that that's not the case. It had been a little bit frustrating for him. And I know that the school had been having some trouble getting a hold of the parents. So he tried to do it himself. He was told to leave. He was treated quite poorly by the officers there. As he was being escorted, he was being shoved around. And Mr. Kane was just trying to not be shoved, trying to protect his own personal space. We have a child who's just trying to go to school, and then he gets arrested because he doesn't want to be treated poorly. He does live with his parents because he's a rising junior. I've contacted them. They know what's going on. Last I was on the phone with them, they were on their way to the jail to try and bail him out. I let them know that even if Your Honor grants him a signature bond, they would have to sign him out, basically out of the jail. I'm asking for a signature bond, Your Honor.
Do you know the names of the parents, Ms. Wright?
Yes. So mom is Nasha Kane. But I don't know stepdad's name. I do have their number, however, if the court would like it.
Okay. Is his mom coming to get him?
Yes, Your Honor.
Okay, can you spell that name for me, please?
Yes, Your Honor. It's Nasha. And the last name is Kane.
Okay. And this happened back in January, is that right? I have a offense date January 30th, is that right?
I believe so. Yes, Your Honor.
Okay. It's going to be $1,000 signature bond through the jail. He is to be released to his mother, Nasha Kane. I would like for him to be re-enrolled in school if that is possible, but he's to stay away from the Hamilton Holmes Drive address. It was at Douglas High School until he is appropriately and properly enrolled in school. No drugs, alcohol, or weapons while out on bond.
Yes, Your Honor. Thank you.
All right. Good luck to you, Mr. King.
Thank you.
Next, we have position number 2, Ms. Bynum.
Good afternoon, Ms. Bynum. I'm Judge Eric Morrow. This is the State Court Expedited. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Yes, Ms. Bynum, can you hear me?
Yes.
Okay, thank you. You've been charged in case 23 CR 003879H with criminal trespass. Is there a history, Ms. Roberts?
16 cycles. Last arrest was May 24th of this year for criminal trespass. Appears to be on probation for criminal trespass from that case, 23 CR 003-300C. That is, disposition was June 8th of this month, 12 months probation. Theft by shoplifting conviction, 2012. Driving without a valid license conviction, 2011. Criminal trespass, simple battery conviction, 99, and a burglary conviction in 1990. 2 FTAs, 2 probation violations. Nothing further.
Mr. Walker?
Yes, Your Honor. In this case, law enforcement was dispatched to 2273 Country Club Drive. They spoke with the owner of the home, Miss Eunice Bailey. She is the aunt of the defendant. She advised that her niece, who is the defendant, keeps returning to her property. As pretrial mentioned, this defendant just entered a guilty plea in front of you, Judge Morrow, on June 8th with a criminal trespass at the same exact location. She was ordered to stay away from this property location as a result of that plea. Miss Rosella Bowers is on the line. She is the victim's caregiver. We have had contact with the victim along with her caregiver, Miss Bowers, and it has been advised to our office that the defendant has returned to this property every day that she has been released. I mean, every day since she was released on June the 8th. She has broken a window on the property, and she uses that window to come into the home and sleep there at night, even though she's been criminally trespassed numerous times in the past. We would like to sound for Miss Bowers as she is on the screen, and we are asking for a $2,000 surety bond, no further contact with the victim, Miss Eunice Bailey, and a stay away from the incident location.
Yes, good afternoon, Ms. Bowers. If you would like to address the court, I'll need for you to unmute yourself for me, ma'am, and raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Miss Bynum has been on that property every day, and the one that she broke out, she put her hand through to let herself in She was there at 4:30 in the morning, just standing over Miss Jones Bailey. And you know how nerve-wracking that could be. Somebody in your house, don't supposed to be there. 4:30 in the morning, wake you up. And she's done this. We barricaded the door. So we found out she was coming through that door, through that window right there, unlocking the door. And she still just pushed her way in there. And she won't leave. She just won't leave. Every day is something with her. It's no peace at that house. None.
Okay, thank you, Ms. Bowers.
You're welcome.
Ms. Wright.
Your Honor, I believe that Ms. Bynum could probably benefit from speaking to our social workers. So if Your Honor would grant some form of bond, a reasonable bond, and she's not able to make it, maybe at SAP, we could relook at the bond with the help of social workers, maybe find her some other place that she could stay where she doesn't need to return to that location.
Okay, at this time, I'm going to grant the state's request for a $2,000 surety bond. She's to stay away from, have no further contact with Ms. Bailey, stay away from the Country Club Drive address, no drugs, alcohol, weapons while out on bond. If you will have a social worker visit her, Ms. Wright, and report back to me if she doesn't get out on that July 6th state all-purpose calendar, I'll take a look at it again at that time.
Thank you, Your Honor.
All right, good luck to you, Ms. Bynum. And thank you, Ms. Bowers. We appreciate you being here, ma'am.
This is position 7, Good.
Good afternoon, Mr. Good. I'm just Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 003878C with simple battery family violence. Is there a history, Ms. Roberts?
That's one cycle on his GCIC from June 15 this year for possession of marijuana less than an ounce. That was what AP did.
Okay. Mr. Eggers?
Yes, Your Honor. Back on March 23rd of this year, Mr. Gould at a convenience store at 2189 Jonesboro Road, Atlanta, Mr. Gould confronted a vehicle that contained where the victim is one of the passengers. They had lived together before, but not currently. He began arguing with her through an open window and then struck her. And the report says the victim's tooth was knocked out, so it appears to be a pretty severe strike. He's fairly young. He has a open marijuana under an ounce case. The state is asking, he appears to have significant personal hostility towards the victim. So for that reason, the state is asking for a $4,000 surety bond, a no contact with victim, a stay away from incident location, the convenience store, no drugs, alcohol, weapons, and an anger awareness class.
Yes, Your Honor. Mr. Gould is 18 years old. He's lived in.
That's right. I'm sorry. I asked a question of Mr. Eggers. I need to.
Sorry.
No, you're fine. I need to get the alleged victim's name.
Oh yes. And we need to sound he struck Stephanie Cherry. And at this time, if we could sound for Miss Cherry.
If Ms. Cherry is on the Zoom call with us and would like to address the court, now is your opportunity to do so. Does not appear so, Mr. Eggers. Now, Ms. Wright.
Yes, Your Honor. My understanding is that Ms. Cherry is actually incarcerated at the Cobb County Jail on theft by receiving charges. Mr. Gould has lived in Georgia all his life. He's 18 years old. He works at Church's Chicken, where he works the register, and he also helps to prep. So the charge is simple battery, but they're also alleging some kind of dental injury. It doesn't make a whole lot of sense to me. Mr. Gould let me know that he didn't even know that there was a warrant out for his arrest until he was arrested. Your Honor, I will be asking for a signature bond for Mr. Gould today.
Where does he reside, Ms. Wright? He's 18, is he on his own?
He resides at 2980 Jonesboro Road, apartment 270.
And who does,
I
is
think
he?
he lives on his own, Your Honor.
Okay.
Oh, do you live with your parents, Mr. Gould?
I
You
stay with
do.
my mom.
With your mom?
Yes.
And I do have her name and phone number if Your Honor would like it.
Okay, so yes, please. What's her name?
Her name is Tiffany Brown.
I am going to send him through pretrial, Ms. Wright. As such, he is going to need for Ms. Tiffany Brown to come and pick him up. And he's also going to need for her to bring with her a utility bill to prove that where they live. So it'll be a $2,000 signature bond through pretrial per the judge. 1-day anger awareness. Stay away from the 2189 Jonesboro address. No further contact with Miss Stephanie Cherry, and no drugs, alcohol, or weapons while out on bond. So if you'll inform Ms. Brown that to retrieve her son, what she will need to do to get that done.
Yes, Your Honor.
All right. Good luck to you, Mr. Gould.
All right, thank you.
You're welcome.
Next, we have position number 9.
Yes, good afternoon, Ms. Holmes. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Holmes, you've been charged in case 23 CR 003873E with battery family violence and simple battery family violence. Is there a history, Ms. Roberts?
5 cycles, last arrest January of this year for criminal damage to property and simple battery. That is an open case, 23 SC 186473. And then appears to have an open case out of Clayton County for violation of Georgia Controlled Substance Act from 2021. And nothing further.
Speaker staff.
Yes, Your Honor. So this incident occurred June 17th of this year at 5335 Wexford Circle in South Fulton. And so this is where officers spoke with Miss Jasmine Williams, who told them that her 2 sisters, the defendant and Miss Quindasia Turner, were arguing about not going to the defendant's baby shower. And so when Miss Williams tried to break up the argument, break up the fight between them, the defendant pushed Miss Turner into Miss Williams, causing Miss Williams to have a busted lip. And so Miss Turner told officers that when she told the defendant, when she told her sister that she wasn't going to go to the baby shower, that the defendant got upset and began to constantly push her until she was pushed into her other sister, Miss Williams. The defendant left the home after the incident, and then she attended her baby shower. And so our victim witness advocate was able to speak with Miss Williams and Miss Turner today. Ms. Turner, she confirmed the events in the warrant. She stated that nothing like this has happened between them two before. And she also let us know that she's had a scratch under her eye and her back was hurting from being pushed by the defendant, but she didn't want to go to the hospital to get any medical attention. She let us know that she doesn't want any contact with the defendant and she wants her to stay away from her residence, which is a different residence from the incident location. And now Miss Williams, the other sister who we spoke to, she let us know that this is not the first time something like this has happened between the defendant and her. She let us know that they have a previous case, and the case number for that is 20 CR 005782Y. And she also confirmed the events and the warrants, and she confirmed that she did sustain a busted lip. Your Honor, she also said that she does not want any contact with the defendant, and she wants the defendant to stay away from the incident location. And that's where they live together, Your Honor. And so for these, well, before I give you the bond recommendation, like pretrial said, there is a open simple battery case and criminal damage case. It's a different address and a different victims. But in that case, the defendant received a $35,000 straight bond. But she also has, and I think it's the case that her sister Jasmine Williams is referring to, a battery family violence case. I wasn't able to open it. Odyssey wouldn't let me open it, but I did see that there was a $2,000 SOB bond through pretrial services from Judge Todd on that case, Your Honor. So for these reasons, the state's recommendation is a $4,000 cash bond, $2,000 for each of the charges, 1 day anger awareness course, no further contact with Ms. Williams or Ms. Turner, and to stay away from the incident location, Your Honor, 5335 Wexford Circle, and to stay away from Ms. Turner's addresses, which is 528 Candler Drive in Columbus, Georgia, and as well as no alcohol, drugs, or weapons while out on bond. And I'll ask for a one-time police escort back to the incident location so the defendant can get her things. And if Ms. Turner and Ms. Williams, I see that they're on the Zoom call, so I would like to sound for them.
Okay, I see Ms. Turner has her camera activated. Ma'am, if you would like to address the court, I will need for you to unmute yourself and raise your right hand for me. Unmute yourself first, though. And Ms. Jasmine Williams, if you would like to address the court, I will need for you to activate your camera and unmute yourself as well. Okay, while she works on that, Mr. Trejo, would you like to go ahead and present?
Yes, Your Honor, I can go ahead and do that. Your Honor, right off the top, I would like to bring to the court's attention that the case that was open, the 20 CR case that was in front of Judge Edie, that case looks like it has been disposed of. It looks like that case was null prost. And regarding with the other case that is still open, that is the two cases. It's a trespass, damage to property, and a simple battery. The damage to property case remains open. However, the simple battery was not presented to the grand jury. So it does not. So without knowing much about that case, or without knowing much about what the status of that is in the DA's office, it doesn't look like the state has elected to move forward on those charges, or at least not at this time. Regarding a stay away order and regarding having no further contact with these other two individuals, that should not be an issue. As the state mentioned, the primary incident was with the individual who lives in Columbus, Georgia. Given the fact that she lives so far away, my client has indicated that will not be an issue to not be there. Regarding the location where my client is currently living, we would ask that the court not issue a stay away order at this time. My client has indicated that she is currently in the process of moving out. My client has been enrolled in the National Guard for 4 years. She indicated to me that she graduated high school in 2019. She did some college, but in the course of completing some of those college credits, she's now enrolled in the National Guard as a reservist, and she's in the process of converting that to full-time enrollment. So she won't be living at the house for much longer, but we feel that a stay away order would not be prudent or appropriate for her. She also indicated to me that at the moment she is only getting about $300 per month from the National Guard. So we feel that a $4,000 bond would be prohibitive to my client, that she simply would not be able to make that bond at this time. Furthermore, Your Honor, my client indicated that she is 22 weeks pregnant, and in terms of her military service, She is supposed to report tomorrow on the 20th to the Dobbins base out in Marietta. And she's in the process of getting a security clearance. Understanding that she does have 2 cases in the past, Your Honor. However, still acknowledging that it is a fairly limited history, and given the fact that the client is trying to remove herself from the situation that she's currently enrolled in, right, with some of these difficulties with her family, we would ask for a signature bond, at the very least, Your Honor, just to give my client an opportunity to see some of these good opportunities that she has in her life, the opportunity to see those through, and to remove herself from the situation that clearly is not working for her.
Okay, Mr. Trejo, your client appears to have her hand up. I don't know if she, if you would like to address her, but Ms. Holmes, you have a right to remain silent. Anything you say can be used against you. I'm happy to give you the opportunity to speak with Mr. Trejo if you would like to do that. But Mr. Trejo, would you like to advise her?
I've advised my client, Your Honor, that that I would do the speaking for the court for her today, given the fact that everything is on the record. And as you just mentioned, she has a right to remain silent, and that she does run the risk of jeopardizing this case if she does get into details about any facts of the case. So, so Ms. Holmes, if you do want to speak, you know, that is your right, but I do want you to be aware that the solicitors are on this call right now, and that anything you say can be used against you, and you're under no obligation to speak.
I just want to mention that I am pregnancy. My pregnancy is at high risk. He did not mention that. That's the only reason I raised my hand. And also, number 2, my mother has access to my phone and my funds, my car keys. I don't have no access to any of my funds at all. Me and my mother is not talking. She's calling people off my phone. I just want someone to know I have no access to any of my at all. My mother does.
Ms. Turner, it appears that you have your audio on now. If you'll raise your right hand for me. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, Ms. Turner, what would you like to tell the court?
On Saturday, my sister, it all started because at first I told her I was going to sit at the park, but it was just me and my daughter, and it was hot. We were by ourselves. She was gonna leave us there by ourselves. So then I told her I wasn't going to, but I was still gonna go to the gender reveal. But she cussed me out about changing my mind about going to the park, just sit at the park by myself. So when she cussed me out about that, I said I'm not going to go. And then that's when she started going off on me. And then when we was arguing, when I was on the phone with my mom, I was walking off and she pushed me down the stairs. And I was going to let it go, but my daughter was there and she seen all of it and she was crying. So I'm going to press charges on her.
Okay, thank you, ma'am. And I don't know if Ms. Williams was able to get her, was able to unmute herself or activate her camera.
I don't know, Judge. She's been logging in underneath several IDs. I think she got it now.
Okay. Afternoon, Ms. Lewis. Thank you. Ms. Williams, would you like to address the court? You have to unmute yourself for me to hear you, ma'am.
I'm sorry.
Okay. Hold on, Ms. Williams. Raise your right hand for me. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell the court, Ms. Williams?
I feel that my sister, she was wrong about the incident, but I don't feel like she deserves jail time over the incident. I just don't want her in contact with me. My sister, Quindasia, she doesn't live in Atlanta, so she won't be near Quindasia, but I just don't want any contact with her. But I don't feel that she deserves jail time for the incident.
Okay, and do you live at was it Waxburg Circle? Is that where you live?
Yes, 555 Westford Circle.
Okay, and you don't want to have any further contact with Ms. Holmes. Is that what you're telling me?
Yes, sir.
Okay, all right. Thank you, Ms. Williams. Anything further, Ms. Bickerstaff or Mr. Trejo?
Nothing further, Your Honor.
Okay, for the battery family violence, it's going to be a $1,500 good bond. For the simple battery, it's going to be a $500 good bond, makes for a total of a $2,000 good bond. No further contact with Ms. Williams or Ms. Turner. She is to stay away from Ms. Turner's address that was previously given. She is to stay away from the Waxburg Circle address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, or weapons while out on bond. Mr. Trejo, if you wouldn't mind explaining the bond to Ms. Holmes and at the conclusion of court today and answering any questions that she has. All right, so Mr. Trejo will be in touch with you, Ms. Holmes. Good luck to you, ma'am. You also, Ms. Williams and Ms. Turner. Who do we have next?
Position 12, Long.
Good afternoon, Mr. Long. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Long, you've been charged in case 23 CR 003872F with improper erratic lane change and driving under the influence of alcohol less safe. Is there a history, Ms. Roberts?
3 cycles, last arrest 2011 for false statements, willful obstruction, and theft by receiving stolen property out of Cobb County. The only conviction out of that case was theft by receiving stolen property in 2012, and then a DUI conviction in 2004. And nothing further.
Mr. Walker?
Yes, John. In this case, Roswell PD stopped the defendant on Alpharetta Street for failing to maintain lane or improper lane change. Upon making contact with the defendant, the officer did observe the odor of alcohol. The defendant did have slurred speech, watery eyes. At that time, the officer did ask the defendant to complete roadside sobriety test or field testing rather. The defendant did refuse all tests. At that time, he was taken into custody. To the one count of improper erratic lane change, we are asking for $1,000 surety. To the count of DUI, we're asking for a $2,500 surety, no weapons, drugs, or alcohol, and to remain compliant with all DDS requirements.
Mr. Trejo?
Yes, Your Honor. My client indicated that in addition to his very limited record, Your Honor, this is his first DUI. He hasn't indicated that he has any issues with drugs or alcohol. While he did refuse to participate in any field sobriety or any chemical testing, we will just put on the record that that is his right, that should not be assumed to that should not be interpreted as a reason for him to have been DUI. We think that there is still a substantial question of fact as to whether or not he was DUI. My client indicated that he was actually giving some folks a ride home after work. A little bit about my client's background, Your Honor. He does have ties to the community. He's lived in Atlanta his entire life. He has 2 children. I'm sorry, Your Honor, I was getting a lot of feedback there. My client does have 2 children that he shares custody with his ex-wife. He's the manager of the Roswell Garden restaurant, where he's been the manager for about 2 years, and he makes about $3,800 a month. And so he's able to provide for his children, Your Honor. He does have a pretty substantial mortgage payment, but given his limited history, Your Honor, given the facts of this case, we feel that that signature bond is appropriate.
And if I could just clarify, counsel stated that this was the defendant's first DUI. I believe I heard a DUI conviction in the early 2000s stated by pretrial.
Okay, I believe it was a 2004 DUI conviction.
Correct.
If nothing further, for the erratic lane change, a $500 good bond. For the DUI less safe, a $1,500 good bond, makes for a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Long.
I'm sorry, I thought I was on. I thought I was not muted. Go ahead and have a seat. I do have a couple announcements.
Okay.
For position number 5, They decided to, I think Miss Anna interviewed him and she wanted him to be reset.
Okay, so is he reset for tomorrow?
Yes, Your Honor.
Okay, so reset for the 20th, 6/20.
Position 11 paid their bond.
Okay,
And also position 14 is gonna be a reset. They refused.
okay, reset for 6/20 as well. What about position 10?
Same thing.
Yes, Your Honor. We would also ask that he be reset for tomorrow for the same reason as some of these other folks.
Okay, so position 10 is reset for 6/20 as well.
Thank you, Your Honor.
Yes.
Can I ask the reason for the reset for position 5 and position 10? Is it medical reset or?
Yes, it's a medical
Would be
reset.
medical.
Okay, I just want to put in my notes. Thank you.
Okay, and I believe that completes everyone. Is that right, Francois?
Yes, that is completed, Judge Morrow.
Okay, very good. Thank you all. We appreciate it so much. You all be safe, okay?
Thank you. Be safe. Have a good one.
Okay, you do the same. We'll see you next time. Ms. Bridgewater.
Yes, once again, the reset date for the SAP calendar is going to be July the 6th. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2 is going to the SAP calendar with the $2,000 good bond. Position 3 is reset further notice with a $1,000 SOB through the jail. Position 4, reset further notice with a $3,000 SOB through pretrial per judge. Position 5 is being reset till tomorrow. Position 6 is reset further notice with a total $1,000 SOB through the jail. Position 7, reset further notice with a $2,000 SOB through pretrial per judge. Position 8 is going to the SAP calendar with a total $1,000 good bond. Position 9 is going to the SAP calendar with a total $2,000 good bond. Position 10 is going to be heard tomorrow. Position 11 is reset further notice as the defendant has been released. Position 12 is reset to the SAP calendar with a total $2,000 good bond. Position 13 is going to the SAP calendar with a total $1,000 good bond. Position 14 is going to be heard tomorrow. And position 15 is reset further notice with a $2,000 SOB through the jail. Are there any questions, comments, or otherwise? I can't hear you, Judge. You chopped up.
Oh, if not, you all enjoy the rest of your holiday. Can you hear me now?
Yes.
Okay. Y'all take care. Be
I
safe.
will ask briefly to be placed in a breakout with Ms. Holmes, as the court asked me to speak with her about her bond.
I think she's
Before everybody-
probably, I'm not sure if she's still in the courtroom, Mr. Trejo. Are you able to call her?
I can call, yes, sir.
Okay, if you wouldn't mind doing that, okay?
Sure thing,
All right.
Your Honor.
You all take care. Thank you.
Thanks, everybody.
Bye-bye.